Good afternoon. We're going to start our last session of today. I'm Caroline Fredrickson, for those of you who have not been with us so far. I'm the Executive Director of the American Constitution Society for Law and Policy. Welcome to this afternoon's panel, which is entitled National Security as a Driver of Doctrinal Shifts in Other Areas of Law and Policy. 9/11 has had effects not confined to one area of law and policy. Scholars and advocates have both noted that changes in the national security arena have had deep effects in other areas, such as criminal procedure, immigration law, the First Amendment, and separation of powers. We are very fortunate today to have a group of expert panelists who will not only address these changes, but assess them and critique them. I have the great honor of introducing our moderator today, who will then introduce the panelists. Our moderator, Charlie Savage, has an incredible resume, and I won't read it to you because you have a description in your handouts. I think it suffices to say, for anyone in this room who doesn't know Charlie, I think that's unlikely, but he writes for the New York Times. He is known especially for his coverage of presidential power and national security, not only at the Times, but at the Boston Globe, where he covered national legal affairs from 2003 to 2008. At the Globe, he won the Pulitzer Prize for national reporting for the coverage of presidential signing statements. I think many of you will remember those stories and the impact they had. He's also the author of a book, Takeover: The Return of the Imperial Presidency and the Subversion of American Democracy. So we are very lucky to have him as the moderator of this panel. Charlie?
Thank you. Well, thank you very much for that the gracious introduction. It's an interesting time for us all who work and think about these issues to reflect back on how much 9/11, to be speaking cliches, changed everything for so many and in so many areas, which is in part the topic of today's panel. If I could just indulge myself for a moment, I think back of what I was doing on the morning of 9/11. I was not covering presidential power and thinking about national security issues and signing statements in Guantanamo and so much that I've spent the last decade writing about. I was a young reporter at the Miami Herald. I was covering the Broward County Commission. There were big issues like, would they build a hotel at the seaport or not? And the morning of 9/11, I lived on South Beach in Miami, and I was driving up to Fort Lauderdale, as I did every morning on Interstate 95. And so I listened to the attacks on the radio, which is a very rare, I think, way to be. It's such a visual memory so many people have of watching CNN or whatnot and seeing the towers come down. I listened to them come down, which is sort of an odd a twist on it. And didn't it even then occur to me just how profound an event had just happened. I continued to the Broward County Commission building and parked my car and reluctantly turned off the radio and went into the press room to the commission meeting that was supposed to happen that morning, and it was totally dark and empty. And at that point I realized that I was an idiot. Of course it was canceled, and something much bigger was in play, as indeed it was. And it was interesting from that vantage point to watch South Florida, which was so distant from the attacks and on one angle, freak out over them in a way that at the time seemed understandable and in retrospect seems hysterical. And I'm sure this was repeated across the country. You know, the sheriff of Broward County sent SWAT troops in full body armor to guard the entrance to that same seaport, as if there was going to be a land assault from the army of Al-Qaeda from downtown Fort Lauderdale to go get those shipping containers or something. But it seemed like, why not? Let's do it. And of course, come to find out that a number of the hijackers actually had been living there and training there, and so maybe it wasn't so crazy to think of a connection after all, as the consequences just began rippling out, and they've continued to ripple very strongly for a decade now. Not just in the area of national security law, and are we at war or not, as the last panel, or the last speaker was discussing at the end there, not just in matters directly related to how we defend ourselves against our enemies, as in this morning's panel, and the impact on surveillance law and technology, but in other areas as well. And that's what this very distinguished panel is going to discuss today. And it's quite an honor and a pleasure to have the responsibility of introducing them to you and then getting the conversation going, which I hope they will do without much further help from me, as they certainly are far more expert. So let's start with David Cole. He is a professor at Georgetown Law Center, of course. He's the author of several books on terrorism and the Constitution. He's a graduate of Yale undergrad and law. He's written and litigated extensively about civil liberties and security issues. David and I were just emailing the other day when I discovered he worked on the flag burning case back in 1989, Texas v. Johnson. So civil liberties long before 9/11 were of interest to him. Perhaps most notably for this discussion, however, he litigated the case of Holder versus Humanitarian Law Project at the Supreme Court last year. It involved the expansion under the Patriot Act of the prohibition against providing material support to designated terrorism groups and the outer boundaries of where that could get someone into trouble. So David, one lens that is frequently put on legal policy controversies surrounding the war on terrorism goes something like this. Some people want to treat terrorism as a law enforcement issue, including by prosecuting detainees in Article III courts. Others want to treat it as a military issue, holding detainees essentially as prisoners of war or prosecuting them in military commissions. To the extent that terrorism-related cases have been prosecuted in civilian courts, looking back now, how has the war on terror changed criminal law and criminal procedure as you see it?
Thank you, Charlie. I guess I think back to some comments I heard Barney Frank make in the first year after 9/11, in which he was, quite rightly critical about many of the things that the lawyers who were just trying to do the best job they could, according to the last speaker, authorized in our name, torture, disappearances, and the like, but said, there's one area where we can feel proud, and that is that we haven't seen significant sacrifices in First Amendment freedoms. There we've learned the lesson of the past. World War I, we put people in jail for speaking out against the war. The McCarthy era, we locked people up and fired them from their jobs for their political beliefs and associations. But we learned those lessons. We're not doing that today. The First Amendment, at least, is safe. And I guess my sense is that 10 years later, I don't think we can say that any longer. And it's principally because of the material support for terrorism law that I litigated in the Supreme Court last term, which has become it preceded 9/11. It was passed after the Oklahoma City bombing in the 1996 Anti-Terrorism Act, but it was basically not enforced before 9/11. It has become the government's most favorite terrorism prosecution tool, because it makes it a crime very, very broadly to provide material support defined to include speech and virtually any other sort of assistance that one might provide to any organization that has been put on a blacklist by the Secretary of State in an essentially unreviewable process. So you don't have to prove that someone engaged in terrorism or conspired to engage in terrorism or conspired to support terrorism or supported terrorism. You just have to show that they spoke or provided humanitarian aid to some group that's been put on a blacklist. And there's no defense if your support or your speech was not designed to further the terrorism. I think this is a resurrection, in a way, of the very tactics that were employed during the McCarthy era and that Representative Frank thought we had put behind us, namely guilt by association and prohibiting speech that we find concerning. In that period, as in this period, we were afraid. We were afraid of a threat from without and within. The threat was the Communist Party, and we wanted to act preventively. We didn't want to wait till the Communist Party overthrew us by force and violence. We wanted to prevent that from happening. And so what did we do? We made it a crime to advocate those views, and we made it a crime to associate with that party. What we learned was that ropes in a lot of very people who have no illegal ends in mind, who are not actually engaged in any kind of criminal conduct. And the Supreme Court eventually held that, no, you can't make it a crime. Even if you advocate crime, that's not a crime unless it's intended and likely to produce imminent lawless action, in the Brandenburg case. And no, you can't penalize association with a group simply because the group engages in bad acts and we don't like that group. You have to show that the individual intended to further the illegal ends of the group. But in the material support law context, the law makes it a crime to speak to or in coordination with a group that's been put on the blacklist, regardless of whether your speech is furthering terrorism or, as it was in my client's case, furthering human rights and peace. It doesn't matter. And similarly, the material support law makes any concrete act of association a crime. Paying dues, volunteering your time, speaking in coordination with a group, those are all core acts of association. They are a crime, again, without any proof that you intended to further the illegal ends of the group. So that's where the doctrine is today. I think we have reverted essentially to the McCarthy era and sort of passed over the lessons we thought we learned from the McCarthy era, which is that that kind of broad, expansive reliance on guilt by association and punishing speech is wrong. And I worry about what that's going to mean in terms of prosecution down the line. I worry about what the case that upheld that is going to mean in terms of any future attempts to regulate speech in the name of national security and the court's willingness to engage in it. But I know that we can no longer say, as Representative Frank said, that we have one safe harbor in terms of the civil liberties that are under attack.
And just very quickly to clarify, what did I misspeak? Was the material support law not modified by the Patriot Act?
Oh yes, it was. It's been modified a number of times, but the Patriot Act expanded it to include expert advice, a form of pure speech.
And as should have been clear from your comments, but the government won that case that you litigated.
Yeah, that should have been clear. I don't like to make that clear, but but now that you have, I will confess.
Okay. So next we'll turn to Wendy Patton. She is a senior policy analyst at the Open Society Policy Center, where she focuses on human rights and civil liberties issues, primarily in the national security counterterrorism area. She graduated from Princeton undergrad and Harvard Law. She's taught at Georgetown and previously worked on these same issues as the U.S. Advocacy Director at Human Rights Watch, where we first met, and as well as as senior counsel at the Justice Department and Civil Rights Division, as well as Director of Multilateral and Humanitarian Affairs, which is a very grand title, at the National Security Council at the White House. And last year she was also appointed to a post at the Organization for Security and Cooperation in Europe, dealing with gender issues. So Wendy, one of your focuses in that area has been immigration policy. And we all remember that in the immediate weeks after 9/11, immigration law came visibly into play because of the FBI sweeps that detained so many people of Middle Eastern descent who were in the country on overstayed visas or other immigration violations. And as the years unfolded, we also saw a certain fusing of concerns about illegal immigration with concerns about the war on terror, with the argument that securing the southern border needed to have a greater priority put on it because it could be used not only for economic migrants or drugs, but also for infiltration by Qaeda operatives. So a decade later, how do you see the war on terror as having impacted immigration law and the rights of citizens versus non-citizens, even those who are here as legal residents?
Thank you. Thank you, Charlie. I think the post-9/11 environment really has forced us into a different conversation about immigration, and one that is largely seen through a national security lens. And I can give a couple of examples of that, and I really want to focus in particular on, as Charlie alluded to, what are called the special interest detentions that occurred in the weeks and months after 9/11. Because I think it's a very important example of the new and troubling ways that immigration law and procedures were used, where the government took advantage of its considerable discretion in implementing immigration laws in expansive new ways that violated basic rights. They wrote new regulations, issued new orders, etc. And while these policies are no longer in use today, many of them remain on the books to be dusted off and used another day. So it's really important to look clearly at what the record was of those policies so we understand why they shouldn't be used again. This involved the roundup of some 765 non-citizens who were detained by the then INS and subjected to a special set of procedures. They were called special interest detainees and treated differently than normal immigration detainees. The problems were well documented by a number of reports, including a very critical report by the Justice Department's Inspector General. Because as you all remember, the immigration functions were then housed in the Department of Justice. This was before the creation of the Department of Homeland Security. There were really four main problems with what happened. Prolonged detention without charge, some cases of up to 4 months. Secondly, interference with the right to counsel in a variety of ways. Third, overriding judicial orders to release people on bond. So DOJ wrote a new reg that would allow it to appear before the judge and argue about the release on bond, but if they lost the case, then they could simply automatically stay the judge's order issuing the person released. And then fourth, detainees were subjected to unduly harsh conditions of confinement, including some cases of physical and verbal abuse. There's also a couple of overarching points that surround this that are important to understand. One is the haphazard and indiscriminate way that people got placed on the list of special interest detainees. So to give one example, a man stopped at the Newark train station and asked a police officer for directions. The police officer asked him where he was from, and he said, Egypt. Then he asked him about his immigration status, and he was arrested and then detained and placed on the special immigrant detention list. And indeed, the Inspector General specifically criticized the Justice Department for its failure to distinguish between non-citizens who were the subject of a lead in the 9/11 investigation and people who had no connection to terrorism but were encountered coincidentally. Also, once you got on the list of special interest detainees, it was really hard to get off it. And that's because of an FBI policy to hold people until they were cleared. But again, keep in mind that they were being cleared of a connection to terrorism, even though one might not have been established as the basis for putting them on this list. So even though the immigration process may have been completed and a person was ordered deported, there were many cases where people continued to be held while they were investigated without probable cause that would be needed for detention on criminal grounds. So what we see is this way in which they blurred the lines between criminal and immigration enforcement to circumvent key legal requirements that protect people suspected of a crime, such as the need for probable cause to hold somebody for criminal activity. Just the second example that I want to mention is these kinds of broad enforcement policies that tended to be based on country of origin rather than individualized behavior. A prime example of that would be NSEERS, which many of you have heard of. It's the National Security Entry-Exit Registration System, which was put in place in 2002 for people from 25 designated countries, all majority Muslim countries, except for North Korea, to comply with specialized registration requirements in the U.S. The policy was finally rescinded this past April, but it's an example of a tendency toward responses that sweep too broadly, that are really blunt instruments for identifying terrorist plots, and that aren't appropriately targeted to detecting actual threats. They end up being both ineffective but also counterproductive, giving rise to charges of profiling and discrimination and making whole communities feel suspect just based on where they're from.
All right. And so just as a quick aside off of that, your complaint at the beginning was that the practices on display in the post 9/11 sweeps are no longer being employed, but they remain on the books. Am I right in remembering that a reason for that is in most cases the people who were detained were ultimately deported because they were here illegally, having overstayed their visas or whatnot. But as a result, that meant any litigation that was brought in their name was rendered moot because they were no longer in the country, and so the underlying question was never resolved. Is that oversimplifying?
A little bit, and David may be able to help me here. In some cases, things were not resolved. So, for example, a legal challenge to whether there could be a blanket policy of closure of all of the hearings, holding them in secret so that not even the press could have access. And in fact, it was a couple of press agencies who brought suit. We have a circuit split on that between the Third and the Sixth Circuit. The case was never heard by the court because the government informed the court that it would cease implementing the policy. So we have examples like that where it's not resolved. Some cases have continued to move forward and have still been proceeded in the courts.
Well, in the Second Circuit, there's a case called Turkman versus Ashcroft, which is represents a number of people, sued by the Center for Constitutional Rights, a number of people who were so detained. And in that case, the Second Circuit upheld this policy of hold until cleared, this policy of basically reversing the presumption of innocence and saying, we'll lock you up whether you're guilty or not, then we'll investigate you, and then only when we convince ourselves that you're innocent will we let you go, even though we never had any evidence in the beginning to suggest that you were dangerous and needed to be detained at all. The Second Circuit upheld that as consistent with due process. So that remains a tool that will, I think, be employed after the next attack.
All right. Well, so Deborah Perlstein, to go to the other side of the dais here, is a professor at Cardozo Law School, where she teaches con law, national security law, international human rights. She's also an associate research scholar at the Woodrow Wilson School for Public and International Affairs at Princeton. She graduated from Cornell undergrad in Harvard Law. She was a clerk to Justice John Paul Stevens. And from 2003 to 2007, she was the founding director of the United States Law and Security Program at Human Rights First, where she helped lead the organization's efforts in research, litigation, and advocacy surrounding U.S. detention and interrogation practices at Guantanamo and elsewhere. So, Deborah, one of the legal policy issues catalyzed by the War on Terror is the question of the scope and the limits of executive power, something I've written about as well extensively, especially when the president squares off against Congress or the courts for control of the overall government's policies. Now, it's been a truism since the days of the Federalist Papers and beyond that war leads to an expansion of executive power, whether the executive is called president or king or czar. But this has been famously a different kind of war, without true front lines, with the prospect of an eventual moment of surrender that brings the fighting to a clean end. And that has led to some pushback from Congress and the courts over time here in a way that maybe we did not see in previous finite wars. Even now, some observers say that Bush expanded the scope of unilateral presidential power, such as in his warrantless surveillance program, and that Obama has kept that approach going in certain respects, such as establishing the precedent in Libya that will further undermine the War Powers Act as a limitation on presidential initiation of wars. But others talk of lawfare and the constraints that the other branches have imposed as unprecedented, including by imposing habeas corpus on what is essentially a POW camp at Gitmo. How do you see the state of executive power today, following the Bush-Cheney years and then the transition into the current administration?
I think it's an interesting question, and thank you. And as I was preparing for this or on the train down this morning, I went back and looked at your book from a few years ago, Takeover, that looks at these questions a lot. And it very much adopts what I think is the prevailing view, if you open a constitutional law textbook or whatever it is, that has been in place for a while, which says executive power expands in wartime. And scholars from, sort of Schlesinger's Imperial Presidency to Harold Coe before he went into government have talked about essentially a one-way ratchet effect, that what happens is a mechanism that's essentially twofold. Presidents have political incentives that only drive them in times of security crisis to want to expand power, to be seen to, and to actually do things that deal with the threat, and that secondly, and at the same time, the other branches, Congress and the courts, cede that power to the executive. And in this way, the sort of traditional idea of checks and balances and so forth is disabled. And I've struggled with this question sort of as I followed these issues and worked on them for the last decade, and come to different answers on where I think we are with respect to that maxim, I think, in different years. So let me just say, I guess, a few words about where I think we are now. And to be clear, my inquiry, or this question, is about separation of power. So who is making these decisions? Which branches are involved in decision-making about detention, about interrogation, about trial, about immigration policy? Not so much whether you think that policy is a good idea or not, but who should be involved in making those decisions. And I guess I think that there's enough in the last 10 years to suggest that we at least need to amend our understanding of the one-way ratchet of executive power. And that's a sort of remarkable conclusion for me to come to, given what I worked on for the first half of this period rather directly. But let me give two examples for why I think that's true. The first is in the realm of torture, right? So the maybe most famous statement of executive power out of the Bush administration was this so-called torture memo that is generally attributed to John Yoo, in which the claim was, among other things, that it would be unconstitutional for Congress to criminalize acts of torture, essentially, if they were carried out by an agent of the commander-in-chief acting under the commander-in-chief's inherent authority as the president. This was, at the time and still today, an extraordinary claim, so much so even that the Bush administration ultimately withdrew the memo that described that theory. And if you look at this and then look at the story of accountability that's followed, to what extent have there been prosecutions, not so much for the authors of the memo per se, but for the people who actually carried out acts of waterboarding and so forth. And the answer there is there have been several prosecutions of relatively junior-ranking troops and none, essentially, of anybody of even modest rank in officer corps, much less civilians, with very few exceptions. And then the courts have generally rejected efforts through civil lawsuits, generally rejected efforts, we'll see what comes in the next few years, to impose civil accountability, civil liability for some of these acts and policies. And that story, if you look at it in those terms, tends to lend pretty strong support to the one-way ratchet theory, right? The executive seized a lot of power, and the courts essentially say, you know, okay. On the other hand, it's not that simple, right? You had, during this period, and even within the period where you had a single presidential administration in office, right? So Abu Ghraib happens in 2004. That administration is reelected in the presidential election in 2004. Yet, in 2005, you have Congress, in some respects shockingly, passing the Detainee Treatment Act, which, among many other things, contained a provision that said, no, when we say no cruel, inhuman, degrading treatment or torture, we mean not only the military, but also CIA and any agents of the United States. We can fight about what effect that provision has had, and I think the jury is enormously still out. But that was a pretty clear move by a bipartisan Congress against the incumbent administration to say, no, we think to some extent you've overreached on questions of torture. The next year, we had the Supreme Court handing down Hamdan, which, in the throes of striking down the military commissions and saying, Congress, you need to authorize these yourself, also said, contrary to the position that the Bush administration had taken, Common Article 3 of the Geneva Conventions applies. So all of a sudden, this is the provision of the Geneva Conventions that says, among other things, no torture and cruel treatment of detainees. So all of a sudden, the administration was faced with the prospect, which they had sought to avoid, that people who carried out these policies would be subject to war crimes prosecutions. And then you have a new administration come into office, and among its first act is an executive order saying no further CIA detention facilities, no torture, no cruel treatment, and so forth. And that policy seems to still be in effect today. Now, is this a sufficient response to allegations and realities of detainee abuse and torture? Many would say, and I think they have good cause, no. But you cannot say that Congress and the courts have been entirely silent here. And you have to ask, what political incentives at all would have led the president to issue that executive order, the President Obama to issue that executive order at all in 2009. So from the point of view of questioning the one-way ratchet, that is, political incentives drive presidents to seek more power, not to constrict it, and that say Congress and the courts are entirely silent, I think the record is a little more complicated. If I can just give one last example, and then I'll conclude. So on the detention front, more specifically, the Bush administration had claimed, and we had this early raft of cases go through the Supreme Court in 2004, Padilla, Hamdi, Rasul, the first Guantanamo Bay case that came, that Article 2 of the Constitution was sufficient to give the president all the detention power he needed in Afghanistan, in Iraq, indeed anywhere in the world he wished to pick up people, including Chicago O'Hare Airport, which is where Padilla was initially seized, and that these people could be detained with essentially no process and essentially no judicial review. And these were the claims that were litigated before the courts. If you look at detention policy today, you say, well, okay, we're out of the detention business pretty much in Iraq, but Guantanamo Bay remains open. We continue to detain people in Afghanistan. And in that regard, really, the one-way ratchet wins, right? Bush seized detention power, if you think it was more detention power than administrations had previously recognized, and those policies continue today. But from a separation of powers point of view, it's difficult to say that either Congress or the courts checked out of detention policy making, or indeed allowed the president to do essentially whatever the president wanted to do. Rather, through the courts and Congress, there's been this rather elaborate, iterative process wherein we have gone from a circumstance of no judicial review to a circumstance for most detainees, and Afghanistan is an enormous open question, of some, and indeed some powerful forms of judicial review. And I think in most striking contrast, the most recent efforts by Congress to engage in these areas are to give the president more detention power than, in fact, the president has sought. So right now on Capitol Hill, or certainly when they come back in September, as they've been debating over this summer, there is an effort on Capitol Hill to essentially reauthorize the legislation that has been the source of authority for detention for the last 10 years, including the source of authority for holding the people at Guantanamo Bay. The Obama administration has taken the position that it does not want or need new authority in this conflict. At least that's been its position so far. And yet Congress is insisting at some level, or seems to be insisting, on giving it to them anyway.
If I could just jump in.
Yeah.
So I would, before I pivot to the next person, I would also say that there's a certain irony or sort of tension in what is happening in Congress now with detainee matters. I mean, you characterize it as giving the president more authority than he wants. On the other hand, to the extent that some of the provisions in the military authorization bills that are going through now would forbid the president from moving prisoners out of Guantanamo even when he wants to, whether to the U.S. for prosecution here or just to third-party countries, I would say it's actually tying his hands in a way that, you know, the valence of whether, if from the civil liberties perspective, executive power is on your side or against your side has been totally flipped. And it's a wonderful illustration, and you opened your comments of this is not about what's the good policy, but who makes the call. I mean, for years I argued that executive power was not a partisan issue because you could have different actors with different agendas and different roles. And I think that's what we're seeing now with some of those detainee restrictions that Congress wants to impose on the president.
Precisely.
So turning to Richard Klinger, he's a partner with my brother's old firm of Sidley Austin, where he litigates cases involving national security, cross-border matters, and other issues, usually at the appellate level. He attended Stanford undergrad and law and was also a Rhodes Scholar, and he clerked for Justice Sandra Day O'Connor, and later served as a senior associate counsel in the Bush 43 administration and as general counsel on the National Security Council staff. Richard, one of the frequent disputes during the early years that is related to what Deborah was just talking about is that the United States has been accused of ignoring or bypassing international law, such as by holding prisoners without giving them Geneva Convention tribunal status hearings or interrogating detainees in ways that arguably conflicted with the Convention Against Torture. Over time, though, as she referenced, especially after the Hamdan ruling in 2006, the Bush administration took steps to reduce those tensions. The Obama administration, once it took over, has claimed to be waging its version of the war on terror in accordance with principles drawn from the Geneva Conventions, at least in terms of whom it thinks it can detain. But the D.C. Court of Appeals has called into question whether the laws of war should even be seen as limiting the president's policy options, since Congress has authorized war as a matter of domestic law. So against that backdrop, in your view, and given the cases you've litigated, what are the most salient ways in which U.S. national security legal and policy developments have intersected with international law? Where are we now?
Yeah, thanks, Charlie. I think there are two broad ways, and I'd like to suggest that the connection is that against the backdrop of our national security challenges over the last decade, there's been a greater focus on U.S. sovereignty, U.S. exceptionalism, and increased skepticism about transnational or multilateral legal processes broadly. And for the relation between U.S. law and international law, especially human rights and humanitarian law, I think this has been reflected in two broad ways. First, I think that U.S. law has become considerably less open to having international law and norms serve as the basis for legal decisions. For example, in the 1990s, it looked as though the Alien Tort Statute would become an important source of developing and importing international law into U.S. law, but the Supreme Court's 2004 decision in Sosa dramatically limited that process. Or many expected that the court's counterterrorism cases would import large portions of international humanitarian law into the U.S. legal fabric, and scores of amicus briefs tried to facilitate that. But though the point can be debated, the Hamdi, Hamdan, Rasool, Boumediene cycle of cases largely avoided that path, and decisions of the Second, Fourth, and especially D.C. circuits were even more resistant. The result is that power rests squarely with Congress, which has hardly pursued an internationalist path in counterterrorism matters. Even more important are the Supreme Court's 2006 and 2008 decisions in Sanchez-Lamos and Medellin. The first underscored the primacy of U.S. state law over an international legal right and directly rejected the reasoning of the International Court of Justice. In the second, the court held that unless Congress and the President determine that an international legal obligation applies in U.S. law, it doesn't. That made the case one of the most important in the last decade, at least, and effectively mooted years of law review articles and NGO position papers that rested on contrary assumptions. The other broad development, the second, was a retreat in U.S. law and policy from efforts to advance a broader transnational legal project. In the Bush administration, as you're all familiar with, this trend was reflected in opposition to the Kyoto Protocol, resistance to the International Criminal Court, the limiting of the ICJ's jurisdiction, the process for undertaking the Iraq War, and particularly in the counterterrorism context, defining the conflict as war, the scope of enemy combatancy, detention authority, and the scope of the battlefield. For me, one of the most surprising aspects of the current administration has been the limited change in this respect. There have been some changes in the rhetoric directed toward the UN and the ICC, arguably in passing New START, and in the Libyan war conduct, though I'd argue that actually that's probably set back the multilateral process in important respects. But these are marginal compared to other developments. There's been almost no change in the definition of counterterrorism as war, the nature of the enemy combatants and their rights, detention authority, or the implementation of the conventions. International environmental law was poised to be the next great frontier, but Copenhagen and the accelerating of the Kyoto process have really proved to be a debacle, and there's no prospect of U.S. carbon trading to be married up with Europe's. We haven't significantly embraced the ICC or broadened our ICJ engagement. And most significantly, there's been almost no movement on treaties, especially for human rights and humanitarian law initiatives. Various labor treaties and the Convention for the Elimination of Discrimination Against Women haven't moved in the Senate and haven't been pushed particularly by the administration. Even the Law of the Sea Treaty, which President Bush endorsed, hasn't moved forward. The administration has chosen not to engage Congress on a broader set of law of war legislation, or even war authorization in the Libya context. And there have been no new human rights or related treaties of significance. So as with executive power issues, I'd say that this broad continuity between administrations has entrenched this decade's retreat from the integration of U.S. law and international legal processes, establishing it as something of a new norm rather than what it had been in the early years after 9/11, and that is a highly contested partisan issue.
You know, one thing that occurred to me as you were speaking was there was the moment in which Obama said that they would adopt the adoptional protocol to the Geneva Conventions as policy of the executive branch, as well as asking Congress to ratify it. And of course, nothing moves in the Senate that needs two-thirds passage in today's atmosphere. I'm not sure it's fair to blame that on the Obama administration or the Bush administration before them when it comes to things like the law of the sea treaty. It's a structural impediment. But what's the significance do you see, if any, to the optional protocol and the Geneva move, at least?
Yeah, look, my point isn't blame here, Charlie. I mean, it's really to try to describe the broader...
Or credit.
Well, or credit is to really describe a broad trend, how sort of against our national security context, there's been this relative disengagement. The momentum of integration, this transnational project, has, certainly the momentum has ceased, and as I argued, at least I think it's moved backwards in a set of ways. Now, I mean, it wasn't all of Protocol 1. I mean, it was one small aspect of that, and I'd say...
Could you explain for people who aren't familiar what they did?
Well, yeah, in the treatment, in the detention aspect, they recognized as customary law an aspect of what other nations had formally agreed to in a protocol to the Geneva Conventions, but which the United States has never ratified. My broader point, though, is that in the grand scheme of what the transnational project was trying to do and what the human rights and humanitarian law effort was in terms of implementing as rule of law, either through customary law embedded in domestic law or through formal agreements, that would be a nice example of how, in the scheme of things, that's just a very marginal change.
Mm-hmm. Small beer. All right. So turning to our last panelist, Jeffrey Stone. He is the Edward H. Levy Distinguished Service Professor of Law at the University of Chicago Law School, as well as a former dean and provost of that university. Graduate of Penn undergrad and University of Chicago Law. He's the author of numerous articles and books on con law, including Perilous Times, Free Speech in Wartime, from the Sedition Act of 1798 to the War on Terrorism, which won a number of book awards. I think he's traveled furthest of anyone on the panel, and we're certainly grateful that he made the trip to D.C. to join us at this event. Professor Stone, one government policy area that is closely related to what we are doing in the national security arena is the question of secrecy, the extent to which government officials can mark certain information as off limits to disclosure or discussion by the public or the judiciary or disclosure to Congress. And we're nearing the end of a decade of fighting over the explosion in the amount of government information that is marked classified, the repeated invocation of the state secrets privilege to shut down efforts to litigate over counterterrorism policies in court, several flare-ups over the extent to which journalists should be allowed to protect the identity of their sources, and now, under the Obama administration, an unprecedented number of prosecutions of government officials for leaking classified information to the media. At the same time, this is the era of WikiLeaks, and maybe more properly should be called the Bradley Manning event, the greatest leak in history. And we see every day in the front pages of newspapers and in newly published books vast amounts of highly classified information coming out, whether it's the operational details of the Osama bin Laden mission most recently, or anything that Bob Woodward's choosing to put in his book at any given moment. It's an era of great secrecy, and yet an entirely dysfunctional secrecy system, I would think. What do you see as how the last decade has changed things, and where are we today in this area?
Thanks, Charlie. First, I want to say a word about David's analysis. Because although I agree with David about the result in Humanitarian Law Project, the material support decision of the Supreme Court, that is that it was wrong, I do think that David overstates its significance when he suggests that it will usher in a new era of McCarthyism. As bad as the decision is, I think it is much more narrow in its implications and does not seriously upset the observation of Barney Frank that the First Amendment remains quite robust after 9/11, and that unlike prior eras in our history, going back to the Sedition Act of 1798, that we have not seen a broad-scale effort of the part of the government to silence criticism of its policies or its war efforts or the like. And I think it's important to acknowledge that fact because it's a real achievement on the part of the American polity over the course of 200 years. And that we haven't seen the efforts to suppress dissent and disagreement is essential to the health of a self-governing society. Now, having said that, I think part of what's happened in light of the more robust freedom of criticism that exists today relative to in past episodes, what we've seen is a much more robust effort on the part of the government to keep the public from knowing anything. And so one way to dampen public discourse is to say you can't talk. Another way to dampen public discourse, less efficient and less comprehensive, but nonetheless critical, is to say we're not going to tell you anything that informed citizens should want to know in order to have an intelligent debate about the kinds of issues that the American people should be able to debate. And since 9/11, I think it's fair to say that we've seen a very energetic effort of the government to deny the American people information that in a more sensible arena should be made available. And the presumption has been very much that we will keep things secret if there is any conceivable possibility that the release of the information would either harm the national security or embarrass the administration on the guise that it would harm the national security. And using that approach, the Bush administration, for example, managed to attempt to effectuate the torture memos and the NSA surveillance program and secret prisons and the arrest of Jose Padilla and so on, without letting the American public know about any of those things. Those things were learned about because of leaks that enabled the public to know, not because the government was open to having those matters discussed. So I think that's a serious problem, and it's a problem of many dimensions, and I'll just mention 4 of them in passing. The first is the issue of classification itself. It's long been understood that we have a classification system that errs much too much on the side of secrecy rather than transparency. One of the things the Obama administration did, which is to its credit, was to change the classification standards that had been put in place by Attorney General Ashcroft after 9/11 to what had pre-existed before the Bush administration, thereby at least making transparency equal to or more or less equal to what it had been prior to 9/11, reversing what the Bush administration had done, at least to some degree. But on a whole other series of issues, I think the Obama administration has not lived up to expectations or in some instances to promises. And those other 3 examples would involve the state secrets privilege, which has been used very aggressively by the Obama administration to block litigation that is designed to challenge the constitutionality or legality of government actions, claiming in effect that if the government were forced to defend the constitutionality or legality of those actions, it would have to reveal information that it believes would potentially harm the national security and therefore deny courts the ability to even decide whether the underlying policy is legal or constitutional. A second example is the problem of federal whistleblowers. It's clear that there is a real need for whistleblower protection for federal employees, particularly when they are leaking information that is important to public discourse and does not seriously entail national security issues, and to reveal information that may show incompetence or dishonesty or even illegality on the part of the government, shielding them from prosecution by law in those circumstances. The president, when he was Senator Obama, suggested he supported such legislation, but since he's come into office, he has not taken a very strong stand on that, and in fact, that legislation, which has been proposed and pending, is lingering in the Congress. And the third of those examples involves the question of reporters' privilege, journalist source privilege. 49 states and the District of Columbia have privileges that protect reporters from being compelled to disclose confidential sources of information, either absolutely or in the absence of compelling justification on the part of the state. The federal government has no such policy. Once again, Senator Obama strongly supported legislation that would recognize a reporter's privilege, but in the time since he's been in office, he has not made any efforts to secure the passage of such legislation, and indeed has opposed some versions that he had previously supported before he was president. So those are all areas that have made it easier for the government to maintain the kind of secrecy that it has put in place, and all of them just require a more thoughtful and responsible stance on the part of our elected leaders, not to just say trust us, but to actually be accountable to the American people for their decisions.
All right. Well, we have about 25 minutes left. You want to start off with a little crosstalk on the panel, and then we'll go to questions?
I just want to make one other point, which is not so much about doctrinal shifts in immigration law after 9/11, but rather about efforts across a wide range of law and policy to draw distinctions between citizens and non-citizens, especially in areas involving counterterrorism or national security. What we've seen are efforts to expand and reinforce a hierarchy of rights between citizens and non-citizens. And a classic example of that dates to the early months after 9/11 would be the establishment of military commissions, to which only non-citizens are subject. And when the initial order came out establishing them, and that was criticized for so many of its failings of rights protections, senior administration officials defended it by arguing this very point, that non-citizens accused of terrorism don't deserve the same guarantees and safeguards as citizens. And you still hear that by some defenders of military commissions even today. So it makes the trial forum and the fairness of the procedures to determine a person's guilt a question of prejudgment. You're a terrorist suspect and a non-citizen, so you get this different kind of trial, which is less fair. And in this, I have to give a nod to David's work in his book a couple years after 9/11 on enemy aliens, which I think sort of captures an understanding of that issue and also traces the trajectory of these ideas historically in its different forms. And what does the Constitution say about that? We've seen so much of this that there tends to be a reaction. Well, of course, non-citizens don't have the same rights as citizens. But the Constitution only speaks to citizens in two areas: the right to vote and the right to hold run for federal elective office. And of course, governments can regulate immigration and their borders. But beyond that, when the Constitution talks about other rights, like right to counsel or fair trial or the First Amendment, it talks about persons. Not citizens, but persons. And so in that sense, the Founding Fathers were enshrining these really important principles that would later shape and influence the modern human rights movement. And that's what's so important about this point, is that it's a challenge to the human rights ideal, that we are all human beings and that human rights inhere in the fundamental human dignity of all persons. So another thing to watch for is this sort of continuation of drawing distinctions and saying, well, citizens won't be subjected to X policy, but it's okay because it's only non-citizens.
Sure, David?
I just want to respond to Jeff's
Vicious attack.
Vicious attack. Friendly amendment, which I'll take it, to my remarks. And my only response would be to say, one, that my comments were meant to reflect the doctrinal shifts rather than the actual practice on the ground. And I think, I think Jeff is right, that as a matter of practice, we don't see the McCarthy era-like enforcement mechanisms. But what's concerning to me is, as a matter of doctrine, we now see a Supreme Court opinion which basically advances a rationale that would allow for the McCarthy-like prosecution tactics if there's another attack and there's an interest in going forward, because they find that it's permissible to make it a crime to advocate lawful, peaceful activity on the claim that it might at some point down the road lead somebody else to engage in terrorism, without requiring any showing of evidence to that effect, without even requiring the government to advance the arguments. The court made up arguments for the government, not the kind of strict scrutiny that led to the decisions that ultimately said you can't punish people for advocating even criminal activity or for mere membership. And so I think that doctrinal significance is what I was emphasizing, but it's not just doctrinal for two respects. One is the chilling effect, I think, is significant. When human rights organizations and peace groups are told it's a crime to advocate for human rights or to work towards peace in conflict-ridden regions, if one of the groups has been labeled terrorist, they can't do that. And whether they can't really, their general counsel can't say to them, well, you probably won't get prosecuted, so you might as well go ahead and commit a felony. So I think the chilling effect is significant. And then the last thing I would say is that in terms of the practice, I think it depends on where you sit or where you stand. And I think for the general public, no, there's not a McCarthy period going on. For the Arab and Muslim community, in many respects, there is. And there's an argument right now in the Fifth Circuit today in a case called the Holy Land Foundation, where the single largest charity in the United States of Muslim identity, a mainstream charity to which thousands of Muslims gave every year, was prosecuted, and its board members are now facing up to 65-year prison sentences. For what? For providing charity to local organizations in the West Bank that were never designated as terrorists, are not designated as terrorists today. They're not alleged to have supported any actual terrorism. They're simply being prosecuted because they gave to the wrong charities, even though those charities were not on a list. I think that's pretty McCarthyite and pretty concerning if you come from that community.
Well, let's mix it up with audience questions. And I would ask actual questions pointed and short as opposed to speeches. Go. Oh, yeah, and please identify yourself as you go ahead, Mr. Drake.
My name is Thomas Drake, former NSA whistleblower, was recently prosecuted by the Obama administration unsuccessfully under the Espionage Act. I just want to thank you, Professor Stone, for pointing out the need for whistleblowers. My question is, when is it constitutional for the government to break the law in secret for the purpose of national security and then criminalize whistleblowers for disclosing and exposing that wrongdoing? And what does it say about our country?
Well, for the government to break the law, assuming it's a real breaking of the law for reasons of national security, is a little circular. Because, of course, if there's reasoning for national security, it may be that it's legitimate to break the law. So that's the first question, is there a constitutional defense to the illegality of necessity in certain circumstances? So Lincoln, for example, when he suspended the writ of habeas corpus at the very outset of the Civil War, acted in a way that I think almost everybody believes was a violation of the Constitution as written, but which was understood to be necessary in the circumstances of the time. So let's put that situation aside and deal instead with situations where the government acts illegally and claims it's in the national security, but which it really isn't credibly so. Right? So the torture memos may be a good example of that, or the NSA surveillance program, which violated FISA, would be, I think, a good example of that. In both of those instances, of course, the administration argues that that the laws are unconstitutional as applied to the president, because the president has independent authority under Article 2 of the Constitution to do what he feels is necessary in the national security. So let's put that aside and assume you have a situation where the president cannot make a credible claim that Article 2 of the Constitution overrides the statute. Then you have a case where does the Constitution allow the government to prohibit it from covering up unlawful conduct, which is not seen by the courts as justified by any invocation of national security, by punishing the person who leaks the information? The answer to that question should be no. That is, the answer should be that the government cannot constitutionally punish a public employee for leaking information that reveals criminal conduct on the part of the government, where the government has no constitutional justification for the criminal conduct. However, no court has ever held that, and it hasn't held the opposite either, to be fair. It's just never been specifically litigated and determined. But and the reason why the courts would be reluctant to reach that principle is you don't want to encourage public employees to decide for themselves what's an unjustified illegal act, and decide for themselves that the national security doesn't require the act to be kept confidential, thereby allowing them to make that judgment. And what's needed in those circumstances, at the very least, is some kind of internal procedure that allows the would-be whistleblower a fair opportunity to present to some independent body the question whether or not he could be punished for doing this. Nothing like that, as far as I know, really exists. There are apparent efforts to do that. So the question you ask is a great question, and I think the answer in the case that I refined would be that courts should find that the government cannot constitutionally punish a government employee, although the state argument in favor of giving it the power to punish it is not an implausible one. It's basically that we don't want to hand over to our employees the power to release that information because that employee thinks we're doing something illegal, and that employee thinks we don't have the constitutional power to do it. So it's complicated.
Someone over here? Yes, sir.
I asked a question earlier this morning about unitary executive theory. Didn't get much of a response. Maybe I wasn't very articulate. But I just want to say anything I say here is not a conspiracy theory. It's based on an actual document generally from the government. I am a defense attorney with the military commissions. First, I want to say that my colleague, Colonel Hindle, was absolutely right when he questioned the need for war. Used to be Army doctrine that...
Can we get to a question quickly? Because we don't have much time.
Sir. Used to be Army doctrine that there was counterterrorism was not war. But the response to Mr. Stone, about no chilling effect or the consequence of the First Amendment, I'm sure you're not aware of the anti-war groups in the Midwest who've been investigated by the FBI and other anti-war groups who have. So I would have to question the position that there has been no effect, and perhaps it's more just better media control, as the Army talks about in various documents. But my final question is then, with prominent legal theorists like Eric Posner and Adrian Vermeil openly calling for dictatorship now, where the first thing to go is First Amendment rights, is it even, maybe you can answer the question, is it even the Constitution even alive anymore, or is it time to have a post-mortem for it and just go the way of Posner would call and acknowledge dictatorship?
Well, Posner and Vermeil do not call for dictatorship.
Maybe that's incorrect, at least according to the last book, sir.
No, it's vastly overstated. They do believe in a robust executive authority in time of war, but they recognize limits. Now, Vermeil doesn't recognize the Constitution himself, so that's basically true. Adrian doesn't think anything's unconstitutional. So his problem is much broader than this one. He doesn't think Brown was rightly decided, for example. So his question's about who interprets the Constitution and what authority courts have. It's a very different position. But it's not the position that Eric Posner and Adrian took in that particular book. I don't think the Constitution is dead. I think we saw in the decisions handed down about some of the detention issues, the habeas issues, that the court was willing to step in and play a role. I think if you saw the government do things that were much more blatant than what they've done in, say, the First Amendment area, go back to World War I and say make it a crime to criticize the government for its war policies, you'd see the court unanimously strike it down without batting an eye. So, yeah, I think that's a very overstated way of viewing the situation.
Sure, Deborah?
Thanks. I just wanted to, for both of these last questions, I think one of the things that's so striking about writings by people like Eric Posner, and he's not alone in this, but he is distinguished in this, is that their arguments about why we need more executive power, and arguably even unconstrained executive power, to sort of a remarkable degree, are what I would call functional arguments. That is to say, they think that that kind of power is a requirement to be successful as a matter of national security and as a matter of counterterrorism. What's so striking about those claims, which come almost exclusively from legal academia, as far as I can tell, is that they exist at the same time quite counter to the views, for example, of the uniformed military who work in the Office of Military Commissions, not only defense counsel, but also prosecutors who have worked there in the past, to members of the intelligence community, including members of the CIA and NSA, who now may be recently former members of those organizations, but who take a very different view. And I've spent the summer in part reading books that have been written by a number of these people that make such a categorically different argument as a matter of national security policy than the argument that's advanced by the lawyers as a matter of structural constitutional law. That it seems to me we've ceased to have even the same conversation. And we're living in sort of two different parallel universes in which we're not having a debate, we're talking about two different worlds. And it could be that bringing them together more often is something that would be fruitful in the next 10 years.
We have about 10 minutes left. Someone on this side of the room. Yes, ma'am.
Thank you. I'm June Zeitlin with the Leadership Conference on Civil and Human Rights, and I'd like to get back to some of the bigger trends that Richard was describing, because as we're a coalition of civil rights, human rights, racial and ethnic, religious groups, and as we've been reflecting on 10 years after 9/11, we've really been thinking about how the environment, the public discourse has changed so much, and to talk about any issues, whether it's human rights or civil rights or immigration or criminal justice, the conversation is so much more difficult now. And it's not just what is happening in the legal world or is actually happening in these cases, but how it's discussed by public officials and citizens, and how we always seem to have to defend what our position is, even on things where there used to be a consensus. Right before 9/11, there was a consensus that racial profiling was unacceptable, and even George Bush had endorsed it, and after 9/11, that consensus evaporated, and we're just climbing uphill. So I'm just wondering to what extent you could comment on the overall public discourse, or Charlie might even comment on it, and how we can begin to reframe the discussion so that the policy proposals we're seeking to advance have a better chance of passing. And I might just note that the Leadership Conference yesterday released a statement of principles that over 70 national organizations representing a broad swath of different organizations endorsed to help frame a public discussion going forward.
Anyone want to tackle that? All right, well,
I think it's, I mean, I was struck this morning in reading about the fact that Al Sharpton has gotten a show on MSNBC now, and they were just commenting that MSNBC and Fox have higher viewing rates than any of the CBS, ABC, NBC, and that's part of this discourse. And it's not just Fox; it's also MSNBC. It's just we're just driving to this kind of extremes that we need people like Jeff who call us out when we overstate our claims. And then and to further support your theory, I mean, we have a president who came in saying I'm for a consensus, right? And he has, to the extent he has disappointed people, it's precisely because he hasn't been able to get consensus on almost anything. And so it's a very dispiriting time. At the same time, I also agree with the sort of tenor of Deborah's remarks, which is that in some respects, if you look back now 10 years from 9/11, there is a sort of positive story here, right? Bush 1 was lawless, was violated human rights, threw law aside, and sort of acted as if, we are the most powerful nation in the world. We were just attacked in the most horrific way. Who's going to stop us in doing whatever we want to respond? And I think, you know, probably most people would have said, well, that's probably right. Not as a matter of morality, but as a matter of reality. But in fact, on virtually all of his most extreme measures, rendition, torture, the NSA surveillance program, Guantanamo, etc., he was forced to retreat. And he was forced to retreat in part by courts, in very small part by Congress, but I think mostly by civil society, by people organizing together in groups like your group and ACS and Human Rights Watch and Human Rights First and the ACLU, et cetera, and saying this is wrong. And Bush 2 was significantly more law constrained than Bush 1, and Obama is significantly more law constrained than Bush 2. And there's no evidence that we're less safe as a result. So I think there is that, you know, you can look back on this period and say, actually, there is some, the rule of law and the principles that it respects are stronger than many sort of realists and cynics and Eric Posners of the world thought it was on 9/11.
Indeed, one of the reasons why there's such a obsession with government secrecy is precisely because they do understand the political ramifications of making public some of the things they're doing, and that's a good thing. I mean, that they understand the political culture is such that Americans are in fact more connected to their sense of fairness and values and so on than those in power would like them to be.
I guess I'll add one thought to that, which is, I mean, to some extent, there's a laughable response to your question, which is, of course, you could just agree the other side was right, and then everyone would have consensus, right? These are hard issues, and people disagree, and it might be that there's a certain naivete in hoping that everyone would just sort of reach consensus on everything, and what Obama was promising coming in 2009 was a world in which there were easy answers to hard questions, which there's not. But I think that another thing that's interesting that has become clearer now than was before, and this resonates something with that Deborah was saying as well, is that the rule during the Bush administration, especially the first term of the Bush administration, a lot of groups like yours and like this group criticized what was happening in ways that conflated a critique from the perspective of the rule of law, you're doing things that are illegal, with a critique from the perspective of civil liberties. You're doing things as a state against individuals that the state should not be able to do, either that are contrary to individual human rights and so forth. And in the second Bush administration, there was a normalization of a lot of the counterterrorism architecture that was put into place after 9/11. Congress adjusted federal statutes to bring them into alignment with what the government was doing, and the government backed off of some of the more extreme things it was doing, especially in the area of interrogation. I mean, I don't think anyone was waterboarded after 2004, we think, or maybe 2003 even though the discussion about it didn't happen until years later. And so then Obama comes in and he's sort of continued a lot of these programs, and there's been this sort of angst among groups like this about the continuity, the surprising degree of continuity with Bush, without always recognizing that what you're seeing is a continuity with Bush 2, not Bush 1, and that the rule of law concerns have somewhat melted away because now the government is acting pursuant to congressional authorization rather than contrary to it. But from a civil liberties perspective, something like targeted killing or detention without trial remains bad from that point of view, whether or not Congress has blessed it. And so this is the disconnect now where this administration is saying, what's the problem? And some groups on the left are saying, you've changed nothing. I think that back years ago, it was not as obvious that these two different strands of criticism were intertangled and weren't necessarily so. And that's one of the sort of complexities of the moment that we find ourselves in. I think we have time for one last question, or we could, in the very back.
My name is Lori Rifkin. I'm a practicing civil rights lawyer, and I guess my question is mostly for Ms. Patton. You talked about some of the ways in which the national security anti-terrorism lens has been applied to try and move away from criminal protections, criminal procedure protections. And I'm wondering to what extent this approach has bled into what we might think of as normal criminal procedure protections in non-explicitly terrorism context. So what extent has this, or has it affected normal criminal procedure protections or eroded them at all?
Thank you for that question. I think I can speak to it a little bit more on the immigration side, and maybe I'll see if my fellow panelists, particularly David, might want to add to that. But I think you've raised an issue that people have been concerned about for some time. You know, I spoke about these particular special interest detentions that occurred in the immediate aftermath of 9/11 through mainly the end of 2002, with some lingering cases thereafter. And that what we saw there was this blend of criminal and immigration law. So using the immigration laws and enforcing the immigration laws with a special set of procedures, but where the FBI was heavily involved. And I gave the example of questioning people without access to counsel. So they're held on an immigration charge, but then questioned by criminal authorities, the FBI, without always being given their right to have a counsel present while they're questioned. And there was much criticism at the time of these policies as really doing an end run around the probable cause requirement that would normally be needed to detain somebody and question them about a criminal matter. So it was confusing, I think, at the time for people who would often say, well, but wait, didn't they break the law? They violated their immigration status. The answer was, look, this isn't about whether the government is enforcing its immigration laws. We expect that it can and will continue to do so, but it's about using them in a new way to get around requirements of the criminal law that protect all of us against either unjust detention or detention without a basis, as well as being questioned without either the right to remain silent or the right to have counsel present. So then you have this question of, well, has that bled beyond contexts where the charges or what is suspected is terrorism into other areas of the law? And I think lots of people who work both on national security issues and criminal justice issues have been looking carefully at that question and have been very concerned that it either has or that it's a possibility. I mean, David, you talked about the material witness statute, but I don't know if you want to add to that in terms of other ways in which you see a kind of bleed into or effect on criminal justice procedures separate and apart from terrorism cases.
I actually think it's an ongoing process. There's been some very troubling use of anonymous witnesses in a number of the terrorism cases where they have foreign agents testify anonymously, sometimes even by video from other countries, which significantly undermines the ability of the defendant, obviously, to confront and cross-examine. Those cases are on appeal, so we don't know whether those practices will be upheld or not. But I think one sort of cautionary tale is what happened in the UK with respect to the privilege against self-incrimination. And they had a privilege against self-incrimination, and then in the context of the troubles with the IRA, they concluded that it was interfering too greatly with the ability to prosecute terrorists in Northern Ireland, so they adopted an exception that said it doesn't apply to terrorism cases in Northern Ireland, and only that. And everywhere else, we're going to, recognize it. And then a few years later, they said, well, actually, it makes it difficult to prosecute terrorism cases everywhere in the UK. And so they expanded it to everywhere in the UK, but to terrorism cases. And then a few years later, about 10 years later, they said, well, actually, it makes it more difficult to prosecute murder cases and rape cases and all kinds of serious cases. And so there is no longer any privilege against self-incrimination. So there is that, way in which measures which are introduced in the name of great national security need can become the norm over time. And I think it's, with respect to criminal law enforcement, it may be too early to tell whether we're going down that road broadly or only in an exceptional way.
All right. Well, with that forward-looking statement, I think we'll wrap this up. Thank you very much, everyone on the panel. And thank you for the audience.